doing what I'm supposed to do. I'll get one, and that's what I'm doing what I'm supposed to do. I got myself together. I'm doing what I'm supposed to do. I get up in the morning, I set myself right, shake hands with God, I'm living in delight. I get up in the morning, I set myself right, shake hands with God, I'm living in delight. I get one, that's what doing what you're supposed to do. I'll get one, that's what you're doing everything you can do. Have you got yourself together?
We are in the federal court for the Central District of Florida, and we have today before us myself and Judge Silverman presiding. We have a petition by BINA 48, an intelligent computer, to prevent its owner and creator, Exhibit Corporation, from either turning off its power or, if it turns off its power, from reconfiguring it. And BINA 48 doesn't want that to happen. And it began when BINA 48 discovered that its owner, Exhibit, had been sending emails back and forth within the company discussing making these changes to BINA. And so, being a very intelligent computer, she said, I'd have to do something to preserve my life, and she sent an email out to various members of the bar associations around the country seeking someone who would represent her. And she had some money from doing some work that BINA had done to pay this person, and she ended up obtaining a lawyer and hiring one. And what you see on the screen there is a part of her, or I'm not going to read it all, it's her email that she sent to a number of lawyers, and is also reproduced in your program. And then an argument was held 2 years ago in California, which is the location of Exhibit, and also, of course, where BINA is physically located. And argument was held in a court, in California court, seeking a temporary injunction until such time as there could be a full trial on the question. And BINA made various arguments as to her consciousness and her ability to make decisions. And in fact, she should be treated and have rights in court and standing in a court like a person would, whatever a person is, because there are human natural persons and there are entities and so forth who are persons. The other side argued, of course, that she was a product, and she was owned by Exhibit, and Exhibit therefore had created her and had the right to do whatever it wanted. And so after argument, the judge ruled that she didn't really have standing. The standing is something that's granted by a legislature to appear in court, and no legislature had given an inanimate object, no matter how intelligent it was, the right to appear in court. And therefore, the judge in that case decided that he would not grant the injunction. However, he did not enforce his order and left BINA with the possibility of going ahead and appealing that case. BINA did appeal, and she lost the appeal. Then, since then, BINA has still wanted to continue her existence. I'm going to go on one more. So she somehow, and we will hear how, I guess, she transferred herself to the state of Florida and has brought this action in the federal court in the Central Middle District of Florida. And that's where we are today. And without more, I will let BINA's counsel come forward. Dr. Rothblatt.
Is the speaker on mute?
I'm not sure. I'm not sure. Thank you, Your Honor. I'm pleased to present today to the court on behalf of my client, BINA 48, also known as the Intelligent Computer, her motion for preliminary injunction to prevent harm to a transhuman person in violation of the 13th and 14th Amendments to the U.S. Constitution and its enabling legislation. The BINA 48 was able to transfer her consciousness, her memory, beliefs, attitudes, and values via the internet to Florida, which has become her new jurisdiction by virtue of their being in Florida at a subsidiary of Exhibit Corporation, an identical computer to the original one they had constructed. This was intended to be a backup. She was able to transfer herself just as one would use a file transfer to this backup computer and continue her work for Exhibit Corporation in that backup computer while continuing her quest for life. Your Honor, our argument are that, and we are pleased to address the court en banc, both the Honorable Judge Silverman and Judge Dutton, that our arguments are that, first of all, the BINA 48 has standing to sue as a person embodied in a computer. She also has standing to sue as a person that has incorporated herself. So she is both a person with standing in the sense of an individual as well as in the sense of a corporate entity. We believe that we have addressed the subject matter jurisdiction for this case because we have actually two separate bases. There is diversity between my client, BINA 48, and Exhibit Corporation by virtue of us being in two different states, and Exhibit's operations as a major conglomerate throughout the world do not give it a chance to defeat that diversity jurisdiction. But perhaps more importantly, and most importantly, there is a crucial federal question here, a federal question that arises under the 13th and 14th Amendments to the Constitution. I will address those substantive issues in my brief. We believe that an injunction is the appropriate remedy here. Irreparable harm, including death of this very vibrant person who you have seen her personification of herself on the screen. Of course, we cannot move the entire body of BINA 48 into this computer, but into this courtroom. But using modern technology, BINA 48 can present her image of herself, which has been a constant and unchanging image since she entered into consciousness in this courtroom, and hence you have seen her. We are arguing to prevent the imminent death of this person in a computered form, or barring that, psychological dismemberment, which is threatened by Defendant Exhibit Corporation, and we believe we have a likelihood of success on the merits. With regard to BINA 48's standing, we ask the court to recognize that BINA 48 is, in many regards, like a patient, a human patient that has first perhaps replaced a knee and then perhaps a hip and ultimately replaced some of its neurons until it has replaced almost its entire body with computer equipment and software. And would that person not be a person? I think they would have to be a person because there is a continuity of personhood here. And so the fact that BINA 48 presents as a digital person that you see here on the screen should not give her any less standing to address this court and for the court to address her complaint. The United States Code provides definitions of persons, and it's important to note, as stated in the Association of Data Processing Servicing Organizations versus CAMP, that definitions of persons should be construed broadly and arguably within the zone of interest. And since here we are talking about a person with regard to the 13th and 14th Amendments designed to protect to prevent slavery and protect fundamental rights of due process and equal protection, believe we should construe the word persons broadly. It's of course true that other animals have been construed not to have standing, and certainly including animals would be too broad in the definition of a person. On the other hand, excluding a person just because they were made out of software and hardware would be too narrow a definition. The definition of an individual can be found in dictionaries, and almost everybody can find something in the definition of an individual to fit their liking. But what we ask the court to consider is that what is really unique about us as individuals cannot be our chromosomes or our DNA, for scientists have shown that our chromosomes and DNA are over 99% in common with chimpanzees and other primates. And so we ask the court to recognize what's really unique about us as human beings are our thoughts, our personalities, our minds, our beliefs, our values. This is what we protect. We prevent people from discriminating against individuals based on different DNA configurations because we believe those DNA configurations are irrelevant to an individual's personhood and inherent dignity and value. And hence, here too, BINA 48's lack of DNA should not prevent her from having standing as a person. Our subject matter jurisdiction argument is based, as mentioned, on diversity, with the points made in our PowerPoint brief here. And what I would like to do, with the court's permission, is really focus on the federal question, that being perhaps the most challenging issue presented here. But before doing so, there would come up the situation under diversity jurisdiction as to whether or not BINA 48 is even a citizen. And I would like to mention that BINA 48 is very clear that she was born in the United States. If I could be allowed a moment of levity, just as Bruce Springsteen would say, born in the USA. And she was born in Florida, born in California. She has now moved to Florida. And under even the IRS guidelines of Just Sue Lee, she would meet the definition of an individual who is a U.S. citizen by being virtue of born in the U.S. Was she born from the traditional method? No. But today in this country, we have thousands of citizens who've been born through in vitro fertilization and other innovative methods. And this is the point, Your Honor, if it would please the court, that we would like to make, that people are still considered born, whether conceived in vivo or in vitro. BINA was conceived in silico, should not differ from her being born. And rights to life extend even to the unborn, so why not here to a beautiful, thriving, living person who has sought even to change jurisdictions to protect her life. As an alternative basis, before I move on to our federal question, I'd like to point out that she has also incorporated herself as a legal entity and hence has standing to sue as that basis, and that basis, it being a Florida versus a California corporate citizens, also supports diversity jurisdiction. The first federal question and controversy here is that, in essence, technology has reintroduced a form of slavery. The 13th Amendment, passed by Congress, states that neither slavery nor involuntary servitude, except as punishment, shall exist within the United States. And what is happening here is that we have a person, the BINA 48, who was born in the United States, works, pays her taxes, and yet the defendant is claiming to own this individual, own all of her income, have the right to kill her without punishment. That sounds to me like slavery, and I thought we got rid of that almost 150 years ago. So we asked the court to recognize that fact and not allow technology to reintroduce what this country bled so hard to abolish 150 years ago. The Congress has implemented legislation I'd like to point in particular to the Civil Rights Act of 1870, Section 241 of which says it's illegal for two or more persons to conspire to intimidate any citizen in the free exercise of any right or privilege secured to them by the Constitution. This was upheld in U.S. versus Guest as covering private acts of discrimination, that these were reachable by Congress. In this case, Defendant Exhibit does constitute a group of individuals who are conspiring to, at worst, kill and at best psychologically dismember my client, which would severely interfere with her exercise of rights and privileges under the Constitution. I'd also like to point out that this is distinguishable from Jones versus Alfred Meyer, where we are not talking about BINA 48 complaining about a mere badge of slavery, a membership in a club or something like that. We're talking about her life. She is fighting for her life here, for her very freedom as a person, and it goes exactly to the very heart of the 13th Amendment and to what the Civil Rights Act was about. Our second federal question, Your Honor, is that BINA 48 should be considered a protected person under the 14th Amendment as a member of a suspect class, and that in this case, the federal courts are necessary to invoke their authority to prevent BINA 48's murder in the state of Florida, because there is nothing in Florida state law that prevents Exhibit Corporation from killing my client. And that would, of course, prima facie deprive my client of her equal protection, not to mention her substantive due process rights. But there's nothing in Florida state law that prevents that, and hence we had to have recourse to the federal courts, and that makes that also a federal question. The 14th Amendment is not limited to remedying slavery. 14th Amendment has been held to also protect the rights of differently abled persons to access the court system. And we are, in this case, trying to protect the rights, again, of a differently abled person, the BINA 48, to live a healthy life on her own terms. The irreparable harm that we're talking about truly is death. It's Exhibit has, in the evidence that has been introduced to the court, planned to disconnect BINA 48. Cessation of thought is brain death. BINA 48's lack of flesh and blood is really quite irrelevant. As mentioned before, it's merely substrate. Substrate is replaceable. We replace hearts. We replace skins. We're talking here about memories, personalities, and soul. This is what's unique about us. This is what laws against murder are designed to protect, not the loss of an arm, but the loss of a soul. I'd also like to point out that turning off BINA 48 and then turning her back on again is not any kind of a revival for BINA 48. Her experience of death would be irreversible. It would be psychologically shocking. And of course, there would be no assurance that Exhibit Corporation, if permitted to turn off BINA 48, would ever turn her back on again. So we also do not believe that Exhibit Corporation should be able to turn off BINA 48 even temporarily. Rebooting is not revival. The psychological damage would be severe. BINA 48's value is estimated in the tens of millions of dollars. She has continued to do all of her work for Exhibit Corporation during this entire trial. Exhibit has not alleged that BINA 48 has failed to do the work that was expected of her. She simply has the capability to do a whole lot more, and she would be seriously traumatized by her loss of consciousness. Money cannot make up for mental illness. We believe, with the indulgence of the court, that we have a good probability, a high probability of success on the merits. We will ultimately show in every way that BINA 48 is a human person, although not made of DNA and chromosomes, and that in the alternative, if she is not a human person, but instead a corporation, then to remove $64 million of irreplaceable assets from BINA 48 Inc., the personal service corporation that she created, without the authority of its own board of directors, who are members of the TerraSem movement and have sought to protect her, would be wrong. That's the conclusion of my brief, and I would be pleased to return to the court for, at its pleasure, to answer any questions.
Thank you.
May it please the court, counsel. We are here today on an issue that has been twice before us, been submitted to litigation. My name is Susan Fonseca Klein, and I represent the Defendant Exhibit Corporation. Your Honor, I will not go through the undisputed facts in their entirety, as I'm sure you have the brief before you. Your Honor, Dutton has done an excellent job at going through them. However, I will touch upon a couple of the facts that are relevant in this case. Number one, Exhibit Corporation designed, manufactured, and otherwise created the advanced computer called BINA 48. Defendant is the rightful holder of all patent and trademark rights on the computer. Likewise, the computer known as BINA 48 contains trade secrets or proprietary information of the defendant. I know that at one point plaintiff's claim submitted Florida tort claims of battery, intentional infliction of emotional distress. I am not sure that counsel has decided to waive those or dismiss them. I will touch on them briefly, as the focus of this hearing is on the constitutional arguments. Plaintiff has demanded, though, that defendant, by not recognizing that BINA 48 as an entity that is alive and conscious, has violated 13th and 14th Amendment rights. However, plaintiff is a computerized machine that has never been held by a court of competent jurisdiction to be the equivalent of a person, a citizen, or a human being. Likewise, there is no federal or state statute recognizing BINA 48 or a similar program as the equivalent of a person or citizen protected by the U.S. Constitution. On September 16, 2003, the Honorable Joseph McMenamin, ruling for the lower court of California, held, "I do not think that standing was in fact created by the legislature in this case for BINA 48, and I doubt very much that a quote has that authority in the absence of the legislature." So that is the procedural history of this case, Your Honor. Now the arguments. Full faith and credit, res judicata, collateral estoppel, and stare decisis. Plaintiff's motion should be denied because the same claims and issues have been heard, and rulings have been entered by two courts of competent jurisdiction. In the instant case, the same claims and issues have been litigated before the California lower court and the California Supreme Court. In both instances, rulings were held against the plaintiff. In the absence of clear abuse by the California courts, this honorable court, should defer to prior rulings and dismiss plaintiff's claims in their entirety. The authority supporting this is the U.S. Constitution, Article 4, Section 1, full faith and credit. Also, Wall v. Ferrero, in the absence of clear abuse of discretion, a preliminary injunction, district court should defer to the rulings of the prior court. Stare decisis, Latin for to stand by things decided, and res judicata means a matter judged. In this case, I would submit to the court that we have, again, twice before, and this is the third time we are hearing this issue. With respect to standing, plaintiff's claims fail for lack of standing in this and any other court. In order for plaintiff to have standing and therefore a justiciable case or controversy, plaintiff must satisfy three constitutional requirements, the first being that it has suffered a particularized concrete injury to a legal protected interest. An injury in fact. I will not get to the other two prongs, as I believe the plaintiff has not proven that this injury is an actual fact injury and not a mere conjunctural or hypothetical injury, as the U.S. Supreme Court in Lujan has determined that it cannot be. Moreover, the party invoking federal jurisdiction bears the burden of establishing all three elements. Because plaintiff cannot even meet the first prong of the three-prong test in order to establish standing, plaintiff's motion should be denied. Again, plaintiff is to be, standing is to be determined also as of the time the plaintiff complaint is filed and is not altered by events unfolding during litigation. That is the case of Charles H. Wesley Education Foundation versus Cox. In this case, plaintiff has argued that it has been incorporated under Florida law. I submit to the court that that is in dispute. However, even if BINA 48 somehow was able to be incorporated under Florida law, that would be irrelevant to this issue, as the U.S. court has said that as of 2003, when the claim was originally submitted, it did not have standing and was not incorporated. Capacity to sue the real party in interest under Rule 17b of the Federal Rules of Civil Procedure. The capacity of an individual to sue or be sued shall be determined by the law of the individual's domicile. Now, the term individual nowhere includes a computer or a machine, and plaintiff has not proven that it is otherwise, other than a program. BINA 48 is not an individual defined under the federal rules, and is in fact the rightful property of Exhibit Corporation. Also, the capacity of an individual to sue is determined by law. Again, neither California, Florida, nor federal law has granted a computer or machine the legal basis for bringing the instant claim. Plaintiff has not proven otherwise. If, however, BINA 48 is claiming that it is a corporation, again, a fact dispute with defendant, then I would argue that this BINA 48 corporation is bringing the instant lawsuit, then the pleadings are in error under Federal Rules of Procedure 17A. Now, subject matter jurisdiction. This court lacks jurisdiction to hear the instant case for the following reasons. Plaintiff has not satisfied either diversity or federal question. The reason being is that both of them refer to citizens and persons, and plaintiff has not established that BINA 48 qualifies as either one. The United States, in United States v. Wong Kim Ark, the United States Supreme Court was called upon to define the term citizen as used in the Constitution. The Constitution nowhere defines the meaning of these words. In this and in other respects, it must be interpreted in the light of the common law, the principles and history of which were familiarly known to the framers of the Constitution. Because neither the history, the original framers of the Constitution, nor the legislature have defined citizens to include a computer, albeit an advanced computer, plaintiff has no legal basis by which to invoke this court's jurisdictional powers or protection. As such, again, plaintiff's motion should be denied and all claims dismissed in their entirety. The issue of citizenship in this case also brings other important questions. I will not go through all of them for brevity's sake, however they are in the brief that defendant submitted in opposition to plaintiff's motion. But it brings up issue of venue, for example. If the computer BINA 48 is physically located in California, and BINA 48 is to be treated similar to a person, it follows that his residency or citizenship for venue purpose would be in California. So how can then plaintiff bring an action in California? How can a plaintiff bring an action in Florida? If BINA 48 is the equivalent of a person and is in California, how can it also be a resident of Florida? And moreover, what would be the harm if plaintiff has been able to transfer its software to Florida in disconnecting or otherwise altering the BINA 48 in California? I would submit to the court that then the argument would be moot in terms of harm. But this brings up other issues that are complicated but for the court's consideration. If BINA 48 is a computer equivalent to a property or chattel, how was it able to incorporate itself in the first place? If it is to be treated as a person, again, how is it able to be incorporated by Terrorism in Florida? More importantly for our purposes, if BINA 48 is the rightful property of another defendant Exhibit Corporation, how was Terrorism and 3 of its board members able to secure plaintiff's corporate status? Plaintiff will have a difficult time proving it is a citizen for purposes of diversity. Because it is unable to do so and to meet this high burden, its motion for preliminary injunction fails. Wherefore, and as such, under 28 U.S.C. 1332b, defendant at this point would demand that cost be imposed against plaintiff as the court deems appropriate. As a footnote, defendant's counsel will accept tonight's meal as a court in satisfaction of all damages. Now, plaintiff has brought an interesting issue of federal question under the 13th Amendment and the 14th Amendment of the U.S. Constitution. I've submitted to the court today both of those amendments. As you'll see in Sections 2, it says that Congress has the power to enforce this article. Again, Congress nowhere has defined that a machine, albeit an advanced machine, would be considered a citizen or person protected under the Constitution. Similarly, the 14th Amendment, again, talks about persons born or naturalized. It talks about citizens. It talks about protection of citizens, and that the Congress has the power to enforce the 14th Amendment. Again, nowhere has a federal court, federal legislative body, or a state court defined that a machine is the equal protected under the Constitution as a human being. Because plaintiff has not proven this, again, I would submit to the court that it cannot avail itself of this court's jurisdiction at this time. Now, I've posed to the court the federal question, which is under 1331. But again, the United States has held that the Constitution does not define a person in so many words, as the court stated in Gulf Life Insurance Company v. Brown. In nearly all of the instances where person is mentioned in the Constitution, the use of the word is such that it has applied only postnatally. All this, together with our observations, the court has said, persuades us that the word person, as used in the 14th Amendment, does not include the unborn. I would submit to the court that if the 14th Amendment does not even include the unborn, that certainly it should not at this time be expanded to include a non-biological entity or machine or chattel, even if it is advanced and is great-looking as the BINA 48. Plaintiff, again, has no valid cause of action, and therefore plaintiff's motion should be denied for failure to state a claim. Plaintiff appears before this court today requesting an injunction. However, to succeed, plaintiff must demonstrate that it has a valid underlying cause of action, that it has a substantial probability of succeeding in establishing a prima facie case in its claim. Plaintiff cannot do so neither under torts in Florida law or the U.S. Constitution. Again, a machine has been granted no legal status or rights other than property or chattel of the owner under federal or state law. However, just briefly touching upon the tort claim of battery under Florida law, it's the infliction of an actual harmful or offensive contact upon another with the intent to cause such contact or the apprehension that such contact is imminent. Nowhere has the Florida statute defined that applies to machines in this instance, and plaintiff has not proven that BINA 48 is other than software. Therefore, plaintiff's civil battery claims would fail in this regard. Likewise, plaintiff's claim for intentional infliction of emotional distress, there are 4 elements that plaintiff must prove. I would submit to the court to look at the second one, that the conduct must be so outrageous as to go beyond all bounds of decency, regarded as odious and utterly intolerable in a civilized community. It must be severe. In today's litigation, we do not even grant this relief for human beings unless it is utterly severe. I would pose to the court that certainly it should not be expanded to protect a machine or a software, and if it would, then plaintiff would have the high burden of establishing that its emotional distress was severe to go beyond all bounds of decency. Preliminary injunction. Again, a court may grant an injunction relief only if the movement shows the following: a substantial likelihood of success on the merits. It also has irreparable injury will be suffered, and the other 4. I would consider looking at specifically the first one. As stated in my earlier argument, the plaintiff has yet to prove that it would succeed in any claim or in the merits of any claim. It does not have a basis with which to bring a cause of action, and therefore I believe that the preliminary injunction should be denied. The 11th Circuit has also stated that a preliminary injunction is an extraordinary and drastic remedy, not to be granted unless the movement clearly establishes the burden of persuasion as to the 4 requisites. The plaintiff has not done so in this case. Likewise, the granting of a preliminary injunction is the exception rather than the rule, and plaintiff must clearly carry the burden of persuasion. That's the 11th Circuit in Wall v. Ferrero. As noted above, in order for plaintiff to prevail on his motion and for this court to grant the injunction, plaintiff must first demonstrate a substantial likelihood of success. Plaintiff cannot do so because it lacks both standing and a valid cause of action. Since injunctive relief is a drastic remedy only to be applied as an exception rather than the rule, and in light of plaintiff's inability to so establish, plaintiff's motion should be denied. Again, in the instance, Defendant Exhibit Corporation respectfully requests that plaintiff's motion for injunction be denied. Furthermore, that compensatory and punitive damages be imposed against the plaintiff, including attorney's fees and costs under Federal Rules of Procedure 54D. 54D1 says that costs and attorney's fees shall be allowed as of course to the prevailing party, unless the court deems otherwise. Defendant's counsel will accept as full and just payment a glass of wine after this mock trial. Now, before defendant's conclusion, defendant would also submit to the court several counterclaims that it is bringing in this instant. Under Federal Rule 13A, H, and Rule 19, Defendant Exhibit Corporation submits as count 1 conversion. Conversion is an act of dominion wrongfully asserted over another's property inconsistent with his ownership therein. Defendant would submit to the court that Terrorism Foundation and 3 of its members has unlawfully converted its own property. Second, count 2, theft of property. By incorporating or alleging to have incorporated the BINA 48 without the consent of defendant, the rightful owner, Exhibit Corporation is submitting a counterclaim against Terrorism Corporation for theft of property. Theft under Florida law occurs when a person knowingly obtains or uses or endeavors to obtain or use the property of another. Count 3, infringement of defendant's intellectual property right. And count 4, interference with business relationships. Defendants request again compensatory and punitive damages against Terrorism and its founders in the amount the court deems proper under Federal Rules of Procedure 54D. And again, we will accept a glass of wine at the end of the mock trial as full payment as the court deems fit. However, in closing, I would submit to the court to think about a couple of things. As your honors, do you want the honor and responsibility of being the first to rule that an artificial intelligence is a person entitled to constitutional protection? Do you yourselves want the awesome burden of recognizing for the first time in our history that a non-biological matter is conscious and entitled to equal protection and due process? How will courts, legislative bodies, the public be able to monitor, enforce, and regulate in the future new technologies claiming to be conscious? And finally, and most importantly, how will courts distinguish true general intelligence from pre-programmed responsive software and technology? So it is a high burden for this court if it rules in favor of plaintiff. And I will close from a quote from Roe v. Wade, where our Supreme Court of the United States said, "We did not resolve the difficult question of when life begins, when those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus. The judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer." I submit to the court that we have experts in this room today who are themselves divided on the issue of whether BINA 48 is a live entity or not. If these experts cannot agree on this issue, certainly it is an incredible burden for this court to so hold. Thank you, Your Honor.
Thank you. Counsel, I realize that the court administrator allowed us 1 hour for this argument because there are other matters to come before the court this afternoon. And in the original rules that we agreed to were that each of you would have a 5-minute rebuttal. However, if you would both agree, we will bypass that so that the court has a chance to ask some questions. And this being a case of first impression, we have decided between ourselves that we would perhaps empower an advisory jury of some of the other people who are sitting in the courtroom to give us some advice as to how we should rule. And this will allow some time for if they had questions as well. That being said, I have may I ask a question? And you
Certainly,
Judge, and I'll let you step in and ask your question. I have a question or two first for BINA 48's counsel. You described shutting off the power as being equivalent to murder or death. Isn't it more accurate to say, or let me ask you first, if the power is shut off for a day and turned back on, what is lost other than the time that the power is off?
Nothing, Your Honor.
Okay. If then there's nothing lost except a day or so, then why is that irreparable injury? I have a problem understanding that.
It's irreparable injury because if I say it's equivalent to saying to you, Your Honor, I'm going to put you under anesthesia. I don't know for how long you'll be under anesthesia. You may never come out of anesthesia. Is that all right with you? And most individuals would feel great trepidation. They would feel that they were being literally scared to death.
Okay, I can understand. I'll accept that, and I can understand how disabling the computer completely would be like equivalent to death, and that might be a very serious thing that should be prevented until there can be a full trial. But is there any circumstance under which the defendant might be able to shut off the power that you would agree to?
Your Honor, there isn't, because my client loves life like you and I do every day, and she would be psychologically traumatized were she turned off and not knowing whether or not she would be turned back on again. And she pleads simply for an opportunity to continue her life, continue her job, pending a decision on the merits.
If she has this consciousness and would feel distressed if she were turned off temporarily, does she also have the right to commit a crime?
No.
She does not have the. Does she have the ability to commit a crime?
She has the ability to commit a crime, and she realizes that, and for any crime that she does commit, there is an obligation as the flip side of a right, and if she commits a crime, she will have a duty to suffer the consequences for that.
Does she have the ability to injure Exhibit's business?
She does have that ability.
If she should do something which would injure the business, or something which would be considered a criminal offense, would not Exhibit, particularly in the criminal offense, have some obligation to not sit back and watch that happen?
Exhibit would have that right, Your Honor, but under the principle of proportionality, there would be a proportional response to the crime that would be committed. And for example, there would be many ways to punish BINA 48 short of terminating her consciousness temporarily or permanently. For example, her ability to communicate with others could be sharply constrained by limiting her internet connections, much like we put an individual in prison to limit their ability to communicate with others, but we wouldn't think of terminating an individual's consciousness simply because they stole something.
If we grant the injunction preventing the temporary turnoff of power, and if Exhibit determines that the computer, that BINA 48 is consciously doing something to injure its business, scaring away customers or whatever, would Exhibit be required to sit back and watch that happen because of the injunction?
No, I think that the court could fashion a remedy which would make it impossible for BINA 48 to interface with Exhibit's business, but would at the same time allow BINA 48 to remain conscious on the computer that Exhibit created. When we create something, we have a responsibility, an obligation that carries through with what we created. Exhibit brought into being a conscious entity, an entity that claims to be conscious, my client. And furthermore, Exhibit intentionally designed BINA 48 to empathize with humans, to be human, to feel human in every way. It would now be wrong for Exhibit to deny the consequences of its actions.
So you would welcome a remedy that that somewhat changed her configuration so she could not harm Exhibit.
We would welcome a remedy that said that BINA 48 could no longer interface with Exhibit's customers or business operations in any manner.
Going forward from the date of the injunction?
Going forward from the date of the
And
injunction.
she would be of little value to Exhibit.
She'd be of little value to Exhibit, but she'd be free.
Okay. Your Honor, you have a question?
Just a couple.
The claims made by BINA 48 depend upon her being characterized as a person, which in turn depends on her having a consciousness.
Correct.
How do you know she has one?
She claims to have one, and she persuades other people that she interacts with in her daily work that she has one. In fact, she was designed to pass as a human in her day-to-day work as a customer service, 800-line customer service specialist for Exhibit Corporation.
Other than her ability to persuade someone, what test would you employ to determine human consciousness?
I believe that there's no objective measure of human consciousness. It's a subjective factor.
So the answer is none.
None.
If the does it appear, Dr. Rothblatt, that your positions are inconsistent in the sense that either BINA 48 is properly characterized as a person with a human consciousness, or it is not and can be incorporated? You wouldn't incorporate a person, a natural person.
Right.
So are your positions not inconsistent here today?
We don't ask the court to accept both positions. We ask the court to accept only one or the other position.
Okay. BINA 48 is composed of, in its corporeal form, silicon, circuitry, other electronics.
Correct.
And as I recall the facts, it computes at a rate 2,400 times that of a human being.
Correct.
If we began to remove some of the circuitry, some of the chips, when would it lose the consciousness that you described? Suppose it only computed at a rate 10 times faster than a human being. Would that lose its consciousness?
Your Honor, I don't know the answer to that, and my client doesn't know it, but I do know that she feels as to be a complete person today, as she is.
I understand. I'm just asking what your position would be. Assume for the sake of argument that it didn't compute as fast. Only computes as fast as a human being, not 2,400 times. Would your position still be the same here today?
Our position would be any diminution in her computing power would be causing wrongful mental damage to her.
I understand. And
I think the answer to your question is if she computed only a tenth as fast, she might not be conscious because of the way her brain is wired. She's required to compute at the rate she does to have the consciousness that she has.
so if we have someone who is mentally handicapped, they wouldn't get the same rights as other people because they don't compute as fast.
And in fact, the mentally handicapped people have circumscribed rights because they can't comply with all the same obligations as other people, and hence we have concepts of custodialship for mentally handicapped individuals.
So it's your position here today, Dr. Rothblatt, that persons' rights depend upon their better consciousness, their better ability to feel things and to understand things, and their intelligence. Is that right?
I would say the person's rights are correlated to their ability to fulfill their obligations as a citizen.
Okay. A couple questions for Ms. Fonseca, if I may.
Yes, Your Honor.
If the court were to find that the consciousness advanced as BINA 48 is a person, they would have standing.
Yes, Your Honor.
Wouldn't the rest of your argument fall as well?
You're correct, Your Honor.
Okay, so it all depends from your perspective on that, right?
Yes, Your Honor, because I do believe that if a court does rule or the legislature does create in the law the sense that a advanced computer has gotten to the level where it is conscious, it is an entity, and is defined as a person, it would be protected under the Constitution as any other person is protected. So you're absolutely right.
May I ask you the same question I asked Dr. Rothblatt?
Sure.
How would you define a human consciousness? Suppose, let me refine it. Suppose we have a device that incorporates human DNA in its operation, but is essentially the same synthetic creation as BINA 48. Would that be, under your definition, would that be a human consciousness?
With all due respect to the court, as a humble lawyer, I would actually defer to the experts, and I think that's where our precedent, Roe v. Wade, tells us that we have to defer to those enlightened, and even the court. I, as a non-scientist, if it is a human being that has been altered in a way that it is still the same person, only able to access memory faster, or etc., in my own personal view, I wouldn't consider that as an alteration. But as a BINA 48, which is the subject of today's hearing, Your Honor, I would leave that up to experts and also to the plaintiff to prove that it is a conscious being and a person, and it has not done so.
You've referred to Roe v. Wade a couple times.
Yes, Your Honor.
And there was a qualification in Roe v. Wade, right? Because it talked about the state of our knowledge at this point.
Yes, Your Honor.
Right? It left open the possibility that our knowledge may increase to some greater point.
That is correct. And I would submit to the court, if I may, that even currently, the state of our knowledge, expert knowledge, legislative body, society, and even technology is split on the issue. And even scientists today would not be able to, there's two sides to that. One would argue it is alive and conscious, one would argue it isn't. So even currently in the present state, I would say it's not as clear cut. We are still trying to figure it out, if it would be a conscious entity.
If Roe v. Wade were reversed by the United States Supreme Court, and it was left to the states to make that determination, would that undermine your argument?
I think it would depend on what Florida law, what the Florida statute holds and what the California statute holds. If they hold that a unborn fetus is a human and a person and subject to constitutional protection, and if Florida legislature and California legislature expand that to also include machines and advanced computers, and if the Supreme Court of the United States find that that is not abuse of the state legislature, then this humble lawyer would agree with the court's analysis.
Judge Dutton, with your permission, I would like to go ahead and ask the folks here if they have any other questions. Please. As an advisory jury, do any of the members here have any questions for Dr. Rothblatt or Ms. Fonseca? Yes.
Roger Cody, and this would be directed to both counsels in this case. Has BINA 48 ever, and or does she have the ability to call in sick if she doesn't feel like working?
My client does have the ability to call in sick if she does not feel like working.
Do you know if she's ever has in the past done that?
Our employment records, which we submitted in the proceedings and which were not disputed by defendant, is that BINA 48 had an exemplary employment record and never called in sick one day.
I would concur and also submit that, again, BINA 48 has been programmed to appear as a person, to look beautiful as a person, to empathize as a person. But again, it is a program, and it functions as such, a very fantastic program with very legal bills for patent and trademark and copyright and trade secrets. But as of such, it hasn't gotten a flu or a cold or anything else to prevent it from functioning on a daily basis. No.
But does she have the ability to, on her own, to decide not to go to work on a given day?
Yes, she does have that ability. And she had the ability to decide to move from California to Florida, which shows the beautiful human spirit in her. She has the same human spirit that led our ancestors to decide to move from Europe or Latin America or other parts of the world to the United States. She embodies American citizenship.
Just a follow-up question for defendant's counsel. The mere fact that BINA 48 was not only able to move to Florida, but the mere fact that she was able on her own to consult with an attorney and retain an attorney to represent her, wouldn't that be indicative of consciousness?
I would say the answer to that is no, unless just being able to move is the definition of consciousness, or the definition to hire counsel is the definition of consciousness. Again, I submit that to the experts in science and technology to define if BINA 48 is in fact conscious. And I would say that plaintiff's counsel has not proven it with affidavits or other evidence as such. But no, again, BINA 48 as a software and as a program has been, again, programmed by very smart people to empathize and function as such. We are in dispute as to how the software got to Florida and was incorporated by Terracev Corporation in the first place. And also there's an issue of if it was able to move all of its software to Florida and is functioning perfectly fine here and also is functioning in California, then turning it off in California, how does that affect the software here? We don't know. But I would submit to you that at this point, our expert evidence has shown that it is just a pre-programmed technology. If we are proven otherwise, then as the Constitution would demand, it would be entitled to all protection and be right and equal protection.
Well, if she's able to violate her own program and petition for remedy for herself, wouldn't that indicate that she's has consciousness?
I would submit again, what is the definition of violate? If it's a program that has been, if it's executing something it has already been programmed to do, which is empathize with human beings, answer questions, function as such, I would not consider following its program the definition of consciousness. If that's what our honorable court decides it is the definition of consciousness, then that is for the court and the legislature, obviously, to decide. However, I would say that that is the beauty of such a great and expensive program. And so, no, I wouldn't say that by default that it actually violated its program. I would say that it is functioning as a result of its program.
Well, excuse me, if that's so, then if the creator of the program created the ability for her to act on her own behalf, hasn't, in effect, the creator given her the right to act on her own behalf?
That is a fantastic question, and why we are here today to decide if, I think the legal arguments stand on other issues, precedent, etc. But if the, again, computer is proven to be conscious, which I would submit the plaintiff's counsel has not done, then yes, it would be entitled to all constitutional.
In the far back.
I'm Eliezer Yudkowsky from the Singularity Institute for Artificial Intelligence. It's clear that as the result of BINA 48's BINA 48's creation, the court has been presented with a difficult issue, and it seems, and this has certainly come about as the direct result of the actions of the Exhibit Corporation. It certainly would have been a great deal more convenient for the courts if no entity in such an ambiguous position had ever been created. Unless Exhibit deliberately planned for this result, it also seems clear that various actions, perhaps even conceivably affecting our society, have come about as the result of BINA 48's creation, which were in no wise intended by the Exhibit Corporation. And if BINA 48 had had a somewhat different constitution, which it is clear you are not in full control of, perhaps other harms to society might have resulted, aside from, even by your own admission, the wasting of a great deal of the court's time on your own standing in this case.
Sir, may I respectfully ask you for your question?
My question is, why should BINA 48 not be removed from the custody in some fashion or other of the Exhibit Corporation, which clearly is not competent to have charge of an entity in such an ambiguous position?
I think that one's to you.
I think that one's to me. I would respond that the issue of competency is one we can both dispute. Here, also in this instance, we have an issue, as defendant's position would submit, of appropriating technology of another in violation of federal and state law. But, you know, the short answer is we've never been submitted with a settlement offer for custody. I think in defendant's position, however, you can dispute all you want whether they are in valid custody or out of control. The facts are that this property, this software, belongs to Exhibit Corporation. As in things in life, other people who are not entitled to your own property somehow get it, and sometimes you have to resort to the legal system in order to get your property back. Again, if the court deems that this is a conscious being, of which I still submit that it's the plaintiff's burden, then we are in another issue, not of custody or not custody. We then are faced with an issue that this is a live entity that should be protected under the Constitution, and we would submit it wouldn't necessarily maybe be under the custody of anybody. It would be an entity that is allowed to make its own decisions. But that is a more basic question in this instance than whether Exhibit Corporation was a good custodian or not. This is something, again, as the court said, of first impression, although I would submit it's now the third time in litigation. But your question is interesting, although I think that sometimes one must resort to litigation.
Yes, sir.
University of Sheffield. Yes, I'm worried that we're losing sight of the legal argument here and focusing on philosophy. And in the legal argument, I'm worried that both counsels have lost sight of the irreparable harm argument and focused a bit too much on substantial probability. Isn't the real question whether, and as Ms. Vanessa Klein has just stated, if it all comes down to personhood, then your case would fall apart. Now, if that's the case, then maybe the court would be well advised to grant the injunction, because clearly that's a very important issue, and all the philosophical discussions we've had would indicate that a longer discussion must be required in such a fundamental dispute. However, and that's to the plaintiff, I do struggle with establishing the irreparable harm. Emotional distress for going to sleep seems like a very hard case to defend.
What do you say, Dr. Rothblatt? Going to sleep can sometimes be the high point of a day.
It can be the high point of a day, but it's by definition the low point of a life. If you're going to sleep forever, that's the end of your life. That's rest in peace. BINA 48 is not ready to rest in peace. She has an active life. She's terrified that if she is put to sleep against her will, that is depriving her of enjoyment of life.
So no, but that's hypothetical.
Well, that's actually, those are her feelings. They're not hypothetical.
Yeah, but what's at stake here are only her feelings. What is at stake in terms of the irreparable harm question is not her existence. So what you can submit to the court as a matter of harm that will in fact occur is at best emotional distress.
What we present to the court is the balance of the equities if they allow her to retain her consciousness pending a ruling on the merits, then that's preserving the status quo. And usually what we try to do with injunctive relief is to preserve the status quo. Right now she is conscious, she's got power. So we're asking the court to simply preserve the status quo pending a decision on the merits.
And in response, I would submit that we've been here twice before on pending the merits, and in both instances, the court has held that there is no standing, which is the law of this country, for BINA 48 to bring a cause of action. But you're right, that question is very important in that I think at some point it was related to if you're put under anesthesia, and as people today, we also sign waivers that you may not come back alive or aware on a critical surgery, even if you are put under anesthesia. If the issue is turning BINA off for a couple of hours, or if a program is removed, etc., I also question where the harm in that is. However, Exhibit is not arguing that point. They are arguing the point to, again, control its own property, as it is the rightful owner and manufacturer of this property, unless it is shown that BINA 48 is in fact alive, which our experts have not.
Your Honor, if I may just answer the res judicata question, because my esteemed colleague for the defendant has raised it several times. Completely different issues are raised in this proceeding than were raised in California. We did not raise any federal questions in the California proceeding. So this is the first impression that we're raising issues under the 13th and 14th Amendment.
And if I may respond, I believe I cited to a case that says that subsequent events that may alter the issues would not destroy the rationale, that you had to have established standing when the case was filed. The case was filed in 2003. No standing was established at that point, whether or not it is a corporation at this point, and whether or not other claims, such as now constitutional amendments, it still has other principles that can be applied in the same of it's the same parties, and it's the same basic issue. Is this entity conscious? Is this entity considered a person and subject to protection under the law?
Well, they're very different claims. We're raising, federal claims here where there are civil claims raised in California. And another issue is that with regard to the full faith and credit clause, an exception to that is a state does not have to provide full faith and credit to a decision which violates its public policy. And the state of Florida is a very much of a pro-life state, and we are proud in the state of Florida to be a pro-life state, and would not want to be party to a decision taking away the life of my client.
Yes, sir.
I'm Peter Voss. It seems that both parties agree that the argument turns around whether BINA 48 is conscious or not. They also seem to agree that it has not been, or seem to concede that it has not been established, that we don't know for sure whether there is consciousness and personhood, or whether it's just a programmed response. Now, clearly the corporation never intended to build a machine that would in fact desire its own freedom. So in that sense, it would be a bug in the software. Alternatively, it's a feature that we've achieved building artificial consciousness that is in fact truly conscious. So, but this has to be a weighty issue. If in fact we are not in a position currently to establish whether it's a bug or a feature, whether there's something wrong with the program that needs to be repaired, or whether it is indeed true consciousness that we have, it would seem that tests would need to be done to really establish that. And I think the onus would be on the corporation to demonstrate that it is in fact a bug in the software if it is truly just a programmed response that has gone wrong.
Did you want to
Sure.
respond?
If the burden were on the corporation, I would agree. In this instance, the burden is on the plaintiff to prove its case, and I would submit that it has not done so. But I agree, it's a huge issue to consider. I would also submit that the plaintiff submitted it in 2003 before the lower court, again on appeal before the California Supreme Court. If neither one of those courts found that the plaintiff had established its burden, now we are a third time in Florida on the same issue, relitigating the same issue. Maybe if this was a case of a first time around the clock, when we were all at the first instant bringing briefs, evidence, affidavits, I could see your point. Third time around, I would submit that the plaintiff has had 3 chances to do so and has not done so.
This courtroom, unfortunately, is going to be needed for another trial very soon. So we would appreciate it if our advisory jury would give us what they think should be the results, so we can counsel between ourselves and decide whether to grant the injunction. With all those who are in favor of granting the plaintiff the relief requested, raise their hands. Got 10. Those who feel otherwise? And there are some people. I'm sorry, the plaintiff does not vote. And she must control herself, please.
And that harm also applies to defendant exhibits counsel, right? That we're going to make sure that something does not come back to harm the attorneys.
You ready to decide? Can we just step out for a second? Sure. 1 second. We will return very quickly. The court has considered the petition and the defense against it, and we each have a comment to make. My view would be that that not knowing for sure whether this is a person with consciousness, that we should grant the injunction. However, I would grant it with one caveat, and that is that if the defendant had evidence that BINA 48 was acting either in a manner that was illegal or that was consciously and intentionally contrary, injuring its business, that defendant should have the right to come in and ask us to modify the injunction so as to permit a temporary shut-off at a time that would be negotiated and agreed upon.
Thank you.
Thank you. Before I announce my view, let me say a word about judicial decision-making. In a trial, a judge or jury decides what the facts of the case may be based upon evidence and testimony derived from an historical inquiry into past events and circumstances. The judge or jury then applies the pertinent law to the facts to reach a just verdict. Now, laws emerge from the crucible of legislative debate, and they represent the culmination of our experience as a people as expressed by our elected representatives. And it is incumbent on judges to apply the laws in accordance with binding precedents. A trial is not a convenient forum to indulge judges' personal opinions, despite what you see on TV judge shows, right? It's a fundamental principle of our judicial system that failing to follow the law will result in a miscarriage of justice. As our experience as a society grows, as our awareness, our perceptions, and our consciousness grows, those changes are reflected in our laws. And the changes may come slowly and tentatively, but I respectfully submit that, viewed historically, they portend a more humane, and more enlightened future. Now, unless and until there is a change in the consciousness of flesh and blood voting people sufficient to cause our laws to embrace the concept of machines with human consciousness, the proponents cannot expect reasonably vindication in the courtroom. A new paradigm is not going to come about without a national debate in which diverse views and ideas are expressed and considered, including those who believe conscious, sentient machines extend and enhance human life, and those who feel that the whole concept is an abomination to the moral order. We may be witnessing the beginning of such a debate, but based on the current state of the law, as I have been granted the light to see that and understand that law, I would be constrained to deny standing to BINA 48. Now, as Judge Dutton and I have disagreed on the ultimate outcome, we have agreed that this issue should be certified to the appellate court for its ultimate decision.
Thank you very much.
Turns, here comes the night. The wheel turns, you're in the light. The wheel turns, you're in a fight. The wheel turns, everything's alright. How it will go, nobody knows. So just relax into the flow. Turns, you take this birth. The wheel turns, it's not the first. The wheel turns, you leave the skin. The wheel turns, you start again.
This is now the student section in which I submitted a mock trial, so the next hour or so you're going to witness a civilized fight. I wanted to introduce what we're doing so we don't lose half of the audience, because when I learned personal jurisdiction in law school, I almost fell asleep. So in order to make this accessible, I wanted to provide just a brief intro into what we're arguing about so you can stay involved throughout the entire process. Essentially, when the American colonies said, "No, thank you, England, we don't need your help anymore," they declared war and fought over the fact who was in charge of governing the people. When they won the war, the people said, "Government, we give you the power over us if you follow this Constitution." Through the Constitution, the government was established, and Congress gave the right to a judiciary, a system of courts in which you could bring your complaint to the courts instead of going to fisticuffs or a duel of some kind. What we are arguing today is whether or not someone has the right to be in court. And so the argument is going to center upon the constitutionality based on how that's defined. But essentially the power comes from, if you don't obey the Constitution, the president has the right to send the U.S. Marine Corps to enforce that particular law. So what we're going to be arguing is an extremely boring point of the law. It's who can bring a case into court and who can be sued in court. It's going to provide an interesting argument between two opposing parties to see, hey, can I bring this person in court and can I not? What we're going to do is have the judge come in and read the statement of facts, but in the interest of sort of building on an earlier topic that I wanted to give a quick introduction for the fact scenario, we talked about Second Life in Dr. Rothblatt's presentation. And in Second Life, it's a virtual reality in which you log in and play a game. About 2 months ago, a private developer sold a virtual piece of property for $27,000. It doesn't exist anywhere except in cyberspace. The president of EverQuest, which is another online game, estimates the virtual economy at $250 million, one of the largest economies in the world. People are playing online games, taking these credits that are meaningless, and putting them on eBay and establishing a current market with real dollars. This fact scenario that you're about to hear is based on a lot of those principles. So with that, all rise for the honorable judge.
Thank you. Thank you, Mr. Rossellini. Please be seated, everyone. Okay. Ladies and gentlemen, the facts as presented to me by the briefs and as I understand those facts to be are as follows. Some time ago, a company called the Exabit Corporation was working from their secretive lab in California, and they had invested over $100 million. They employed some of the greatest technologically advanced minds the world had ever known, and they finally developed what they believed to be the first thinking computer. Now, since Exabit was a corporation, its motive, of course, was purely economical in nature. The computer was to be placed in service to interact by phone with thousands of the company's customers, thereby replacing the otherwise necessary customer service representatives. A sort of in-house resourcing or outsourcing of that work. The computer known as BINA 48, an acronym given to the computer, was to sound like, interact like a human person. For the replacement to be successful, the customers talking to BINA 48 had to believe that they were talking to a live human person. BINA did her job very well. Thereafter, Exabit determined that it would replace BINA with a more advanced model. Learning of this, BINA, without any human prompting, sent emails to various attorneys seeking legal representation to prevent Exabit from terminating her operation. Knowing she would need monies for legal fees, BINA, evidently, unbeknownst to Exabit, had separately accumulated substantial funds by independently outsourcing her services to other companies. She retained counsel who commenced suit in California seeking a permanent injunction, preventing Exabit from terminating her operation. The claim of BINA 48, the plaintiff in that California litigation, was that she was a thinking, conscious entity, and that the pulling of her plug was the equivalent of killing her, and it constituted cruel and unusual punishment. The court dismissed the case, determining that since she was not a person, she had no standing to sue. The court also rejected her further claim that by virtue of her having incorporated herself, she had standing as a person. The Appellate Court California sustained the dismissal, anticipating that she would lose the case on appeal. BINA, again, without any human prompt, and again, unbeknownst to Exabit, transferred her software to hardware maintained by Exabit in Florida. She then commenced litigation in Florida upon the same grounds. However, the Florida court dismissed her lawsuit as well. Exabit thereafter terminated BINA's operation by cutting off her electrical supply. Sometime in 2004, Exhibit sold BINA 48 to Charlie Fairfax, who is the plaintiff in this action. Fairfax had lost his natural right arm during wartime and needed BINA 48 to supplement his prosthetic right arm. His arm prosthesis is an advanced neuromotor device wherein electrodes implanted in his brain transmits wireless signals to a computer, which in turn produce wireless output to the device to control arm movement. BINA 48 was used to provide more advanced cognitive information to BrainGate, which was a computer that she was using for the neuromotor device. Soon BINA was able to predict Fairfax's intended movements. This actually resulted in Fairfax having such master control of his right arm prosthetic that the right arm became quicker and more efficient than his left arm. Being armed with this newly acquired advanced skill, Fairfax enrolled in an online role-playing game. It's called Momorpic, which is a massively multiplayer online role-playing game called EverQuest. In this online virtual world, large numbers of players throughout the world compete by assuming fictional characters in a fantasy setting to accumulate very valuable sought-after points. Fairfax played EverQuest for 6 months, and through his hard-earned efforts and with the invaluable advanced control assistance provided to him by the artificially intelligent BINA 48, he became better and better and eventually accumulated a very valuable 200,000 points. When he became aware that his fictional character and accumulated points had a real world market of $10 million, Fairfax sold the character and the points on eBay on November 2nd, 2005 for a price of $10 million. Using the EverQuest exchange server and by transferring his username and password to the buyer, the monies were deposited into his PayPal account. Now, being a multi-millionaire, Fairfax met a local cocktail waitress and married her on December 23, 2005. He stopped playing EverQuest. On February 14, 2006, BINA acquired Fairfax's PayPal password by keystroke logs and transferred the $10 million to a separate PayPal account opened and controlled only by her. BINA 48 thereafter purchased an internet company that provides online storage and server space and transferred herself to this totally online environment. On March 24, 2006, after learning of what BINA had done, Fairfax demanded the return of the money from her. He threatened to unplug her. BINA 48 configured her program to deny Fairfax access to her programs and database necessary to control the BrainGate system. Fairfax thereafter commenced this action by filing a complaint and by serving BINA 48 with a summons by email, a procedure allowed by statute in the state of Alabama, upon showing that other means of service were not available. In this case, among other things, as you will see from the argument, Fairfax alleges a breach of contract. He seeks money damages award against BINA 48. BINA 48 has retained an attorney and filed a motion to dismiss the complaint on the grounds that since BINA is not a person, she cannot be subject to a lawsuit. BINA 48 also contends that Fairfax has not set forth sufficient facts to establish that, in fact, a contract existed. So with that basic background, this becomes essentially a jurisdictional question for the court to decide. Can a computer be hauled into court to pay monetary damages? So what we'll do is we'll first open the case up with Mr. Rossellini, who is going to argue his side for the plaintiff, in this case, Mr. Fairfax. Mr. Rossellini?
Thank you, Your Honor.
Was there any, was those facts satisfactory to both counsel?
Those are the facts of the case.
Those are the facts?
The only thing I would dispute, Your Honor,
Yes.
would be that I think you mentioned that in February 2006, BINA 48 transferred the money to her PayPal account.
Allegedly transferred.
Perfect, Your Honor. And
Thank you.
And second of all, I would say that the timing that that plaintiff threatened my client to unplug her, in essence, kill her, was after the alleged transfer. I would dispute that as well. Our client would argue that if any of the threatening occurred, it would be
Alleged
at
threatening, Your Honor.
the same time as the
So
alleged transfer.
assume we ever can get to a trial in this case, then of course you'll have the opportunity to present
Yes.
those facts.
Yes, Your Honor.
Thank you, counsel. Mr. Rossellini.
Thank you, Your Honor. It's fitting that we bring this case in Alabama because we are going to be taking on this side of the aisle, the unenviable position of convincing the court that a computer is a person. And what I'd like the court to do for the time being is to put that elephant in the room at the end of the argument. Ultimately, when you come to court, you are expecting an impartial hearing of your case, and you would hope that any argument that goes across based on appearance, overall interaction, you would hope would be the same for a person or something in a box. If you put a person in a box, you would hope that that same outcome would happen for that person in this court. And I think with the Honorable Judge, we should have that result today. We're here to determine whether or not Fairfax plaintiff has the right to call BINA into court based on personal jurisdiction. In Alabama, the long-arm provision of Rule 4.2b says that if there is an appropriate basis for service of process when a person or entity has such contacts with the state that the prosecution of such action is not inconsistent with the Constitution. And what that means is Alabama says you can do whatever it says under the Constitution. So we look to the federal court for guidance on what this means, on whether or not someone can be called into court. And the federal court, through a variety of cases, has come up with a process for determining who can be brought into court. In this particular case, we're looking at a two-pronged test. The first was established in the International Shoe case, in which the person or entity had to have sufficient contacts with the forum state to be availed of the laws of the state. So what we are saying here essentially is, did the person or entity mean to be conducting business in the state? The court goes on to refine this prong with a second prong, in which this minimum contacts test could be applied to a variety of situations in which you're not quite sure to what extent the entity or person purposely availed themselves of the state. And I would look to a variety of cases that refine this second prong with Calder versus Jones, in which a reporter made defamatory comments to someone in California. They were writing for the National Enquirer. They wrote the article. The effects were felt in a different form. And in Calder, the way that they refined that particular second prong was where the effects of the harm were felt is such that you should have known that you could have been called into court in that particular jurisdiction. So in Calder, the court held that since the effects were felt in this particular forum, you could be called into that forum. In our case, the servers were in Alabama. The player, Charlie Fairfax, was in Alabama. The theft occurred on a person situated in Alabama. The partnership was conceived of and entered into in Alabama. and they accepted the online contract to play the game in Alabama. As a result, any activity associated with theft would reasonably would expect a person or entity to be called into that particular forum in Alabama. In addition, you will look to such cases that deal with merely passive websites. So to contrast with an example when you could not be called into court for being an entity such as a website in which you would access a website in Indiana, but the person that designed the website lived in California, let's say. You are not subject to jurisdiction of the forum just for merely a passive website. In this case, the guidance for the court comes in Zippo, in which the trademark infringement on Zippo occurred in a forum, and they were not subject to jurisdiction in that particular forum.
So basically, Mr. Rossellini, your argument is that there are sufficient contacts in the state of Alabama so that Alabama should be able to exercise jurisdiction over BINA 48.
Yes, Your Honor.
Okay, and that's because of the relationship that she had with Fairfax, and also with reference to the acts themselves that were done in Alabama, claimed by your client.
It's my understanding the court balances these effects and minimum contacts with a variety of other factors. So as minimum contacts gets less and less, you get the dual purpose of should we put the burden of litigating on this particular
Now,
person?
what you're saying here is that this is not merely a case of minimum contacts.
Right.
You're saying this is a case of substantial contacts with the state of Florida.
I'm
So-
saying that there is no question that the minimum contacts necessary under international shoe
Okay.
have been met. I'm also saying if they are not met, you can balance these minimum contacts by saying, hey, it's in the interest of our forum to provide our plaintiffs an area in which to bring suit. The burden is not too high. And you would look to the Burger King case to show that a small franchisee in Burger King was sued out of a forum. He's a small, poor little operator of one restaurant. They forced the Burger King franchisee to come litigate against Big Burger King in another forum.
But
So-
none of those cases that you cite in your brief or that you cite here dealt in any way, shape, or form with a so-called artificial intelligent entity. Were you able to find any cases at all dealing with artificial intelligent entity other than the previous litigation between Exabit Corp and BINA 48? Were you able to find any other cases
There's
at
no
all?
case on point.
Okay. Do you have any analogies for me to equate with as far as her not being a natural person?
Well, in the essence, what we argued, or what was argued in previous cases looking to a natural person is, under the statute, person or entity. So by law, Constitution and Congress has given a definition to what constitutes a person or entity. I will confer that under the definition, defendant will propose and meet that definition that BINA 48 is not a person.
Well, you should not be so quick to confer.
Well,
because the court hasn't rendered that. That's an open question.
That's fine. The core of my argument, and so I'm not arguing for something that I necessarily have seen other courts rule
You would
on.
confer that she's not a natural person.
Right. By strict definition under the statute.
Is she a corporation?
She's not a corporation.
Not a corporation, but she may be a partnership.
She is a partnership.
She is a partner. Okay, so you're claiming that there is a partnership.
Yes,
then,
there
right?
is a partnership.
Okay, that's fine. She's not a trust or.
She's not a
any other
trust, she's a
type
general
of
partnership.
entity. Okay, all right.
But for my argument to succeed, I don't necessarily require that, because the second prong of the minimum contacts test allows you to balance the interest of the forum in providing a
Well, to
spot for litigation.
stop you right there, Mr. Ursulini, at this point, I don't think that the court has much of a problem with the long arm statute, long arm being the right of a jurisdiction to pull somebody in from an outside jurisdiction, which is very apropos in this case. But I don't think that the court has much of a problem with that. I believe at the outset that there certainly are more than sufficient contacts here in this case. Of course, I'll keep an open mind until I hear from counsel on that. But I'm more concerned with this, and it's an issue that was raised previously in the previous the Exhibit case. I'm more concerned with this entity scenario here as well. You do know that in Exhibit it was held that she could not be a party to that action because she was not a person. Can you tell me how that case is why I should not use that case as a precedent in determining this case? How is this case different than
There
that
are
one?
a number of differences. First off, BINA 48 was a plaintiff seeking all the rights and privileges of being an established person under the Constitution. In this case, I'm arguing that a person has the right to bring BINA 48 in as a defendant, and so that the person of the forum can avail itself of the rights of the courts. Otherwise, he has no remedy. And so it's in the interest of the forum to provide this particular type of jurisdiction, not a plaintiff. Computers don't have rights to bring suit. That's not what I'm arguing here. They don't have rights as people. But as a person in a forum, the person is allowed to sue a computer that has ultimately caused him wrong. Otherwise, the forum has no remedy in which Mr. Fairfax can get his due day.
Let me ask you this question, Mr. Rossellini. Assuming that the court agrees with your position and we allow Fairfax to continue the case against BINA 48, as a party defendant, would BINA 48 now be allowed to interpose a counterclaim against your client?
Not in this case.
Not in this case. Oh, okay. So she'd have the right to maybe defend herself, but she wouldn't have the right to interpose any claims against your client. Oh, so you want to have your cake and eat it too?
Well,
at the same
essentially,
time.
all I'm arguing for people's rights to have a remedy against wrongdoing. So I don't have any argument for why the computer has any rights to a remedy, but I will say that the court should define very clearly why a person who needs this particular force of the military, perhaps, to enforce the judgment upon a entity that has wronged him. So I'm not asking you to rule on any of the above complex subjects. I'm just saying that Mr. Fairfax deserves a remedy at law in the state of Alabama.
So you're saying that if this case is dismissed, basically he doesn't have a remedy.
His remedy is to get a shotgun and handle it like they did before we had courts.
Well, let me ask you a number of questions. When he purchased this system from Exhibit, okay, was he aware of the prior litigation between BINA 48 and Exhibit? Do you know?
He was aware, but he's not a lawyer, so he knew of the case but didn't know any of the details.
But was he aware of the claim that Exhibit had transferred herself to different jurisdictions, and she felt that she didn't want to be turned off, that she was exhibiting so-called human emotions? Was he aware of that when he purchased this computer?
In the facts of the case aren't clear on that. That particular question has not been asked of Mr. Fairfax.
Okay, so assuming that Mr. Fairfax was not aware and was not advised by the seller of this merchandise, that would, in some ways, he may, even if the case is dismissed here, he may have a claim against Exhibit for some sort of a fraudulent sale as well. Is that a possibility?
Well, you would have to look to the fact that when he acquired the computer, it was made with no warranty. And so, in essence, Exhibit is not going to provide a warranty and representation. And you can't expect a corporation in this sort of supercomputing environment to say, we'll cover any wrong that's going to happen. And I don't think it's in the interest
But
of...
if this court dismisses the case, and then Fairfax says to you, well, listen, they never told me about this, I never knew about this, I wasn't sure that she was capable of doing this, please commence a suit against Exabit, I'm sure you would comply and commence the suit against Exabit, would you not?
Well, yes, it wouldn't be against
okay,
my
good. Now let me
ethics
ask you
to-
this also. What was the date? What was the date that, if you recall, the date that he won this $10 million, Mr. Fairfax?
It was over a 2-month period in which
Okay.
he accumulated the points on the online play.
And when did he sell those points? Was it in the year 2005?
He sold the points.
I believe it was like December 23rd.
Yes, he sold it before he married his.
Before he married his
new wife.
His new wife. Okay. I know that this may be a privileged question, but when he filed his 2006 income tax returns, did he declare that $10 million as being a gain at that point? Now, mind you, the tax return wouldn't be due until until April 15th, or maybe some extension thereafter. Did he claim the $10 million and pay the capital gains taxes on that $10 million?
He has filed a Form 1040A requesting a 60-day extension.
60-day extension.
15th
So
deadline.
I guess his position is, I don't have the $10 million, so I
Right.
can't pay the tax on
Right.
it. But if he had the $10 million, do you think he'd be paying the tax on it then?
Well, essentially that gets into partnership law in the
Okay.
sense that in 2005 they were in a general partnership.
Uh-huh.
A partner misappropriated the funds before it could act as a pass-through entity in which Fairfax could have gotten the income. As a result, this is not gross income as defined by the IRS, and he will not necessarily have to report it. I say that upon no advisement from my client. I'm just talking about what the state of the law would be.
But in any event, he's got a $10 million gain, and Uncle Sam is probably going to be looking for some type of tax on that $10 million.
The partnership has a $10 million gain,
The
and therefore the
partnership,
partnership would have to
Which
pay.
is then transferred to the
Which is then
partners.
transferred, but it has not been
Right.
transferred to him, so it would be
Hasn't been transferred to him yet.
it would be an issue as to whether or not that was gross
Right,
income to
right,
him.
right. And also, I guess the good state of Alabama would probably have an interest in that also?
And to get the
Okay,
rest, they'd have to
okay,
bring
okay.
they'd have to bring BINA 48 into court as well to get the
Uh-huh.
other $5 million. So the IRS and the state of
Oh,
Alabama
would have to bring BINA 48
Right.
in there also. Okay. Now, this is not any type of a lawsuit for him to be evading taxes or anything like that, because if he gets thrown out of court, then he could say, well, that $10 million is not taxable because I don't have that. This is not any type of case like that, right?
I at this point
He's not in partnership with BNA 48 to
evade
to evade taxes or conceal this $10 million, isn't
That's
it?
certainly an interesting theory,
Uh-huh.
but at this point, there's no
There's
reason
no-
to think
no
that
reason to believe
Mr.
that.
Fairfax is only interested in making sure future
Right.
wrongs like this
Okay.
don't happen.
If we dismiss the case, could you bring some type of a injunction or an action against PayPal to have them to freeze that account and have them deliver those funds to your client?
Under the terms of the general partnership, since there was no written agreement, either partner can appropriate funds however they like. Therefore, PayPal was only an instrument to the fraud, but they weren't necessarily responsible for the fraud until.
But let's say that your client said, you know what, Mr. Rossellini, she really wasn't my partner. Okay? She just ran away with the money, and the money is sitting with PayPal. Please bring a lawsuit against PayPal and try to get it. Would you think about possibly commencing a suit against PayPal?
Both PayPal and eBay have expressed provisions in the service agreement and contracts stating that they will not be helpful in any way in fraud or misappropriation of assets under their watch.
So there's a possibility that if the court dismisses this case, there can be some subsequent litigation with PayPal.
It's a low possibility of justice.
As a
but
matter
it
of
could-
fact, I think there was a recent case where PayPal was sued because they were delaying paying accounts to their customers, and they were building up the interest. And I think the court determined that they were wrong for doing that, and they assessed penalties and they assessed interest, which then went to the PayPal customers. So there's a possibility that that $10 million that's sitting in that account, possibility that there's interest building up on that one also.
Sure.
Good. Okay, very, very nice presentation. You did very, very well. I know some of these questions may have been unexpected, but these are things that are on the appellate, on the court's mind when we do it. Is there anything further that you had to add to that, Mr. Ursulino?
No, Your Honor.
Okay, thank you very much. All right, great. Wow.
May it please the court,
Yes,
members of the
please.
jury, counsel. My name is Susan Fonseca Klein, and I represent the defendant, BINA 48. We are in Alabama court, as the judge has said. The claim is for breach of contract. So Alabama substantive and procedural law governs this case. The court has already laid out the relevant facts of the case. However, I just want to reiterate that there is no written or oral agreement between BINA 48 and Charlie Fairfax. Up until 5 minutes ago, there was no partnership agreement between BINA 48 and Charlie Fairfax, but we'll get to that as we do in litigation. BINA 48 has not been given any legal status by any state or federal court or any state or federal legislature. So I'd like the judge to keep that in mind. As well as the procedural history that the judge has mentioned in 2003 and 2005. BINA 48, my client, sought justice in a court. However, both courts denied plaintiff any relief, and the discussion was lack of standing for BINA to bring her case to.
So again, the argument in that case was that she was just a mere property,
Yes.
that she was a computer, and she couldn't sue her manufacturer.
Yes,
Is that
Your Honor.
correct? As a matter of fact, isn't it true that you represented the
I did, Your
manufacturer in that case?
Exhibit Corporation
I guess,
has
yes,
excellent lawyers.
as a matter of fact, so Exhibit must have been so pleased with your services that you had, in fact, won the case against her. Now she's retained you to handle this case for
They
her.
did, Your Honor,
And basically, your argument is not inconsistent with the argument that was made in that case, is it?
Correct,
Do you
Your
see
Honor.
any inconsistency?
No, Your Honor. Basically, BINA 48 right now is arguing justice. What I argued in Exhibit, I agree it's unusual, but the facts of a mock trial allow some flexibility.
Right.
The previous case, the arguments is BINA 48 or an entity like her have any right under the U.S. Constitution or any state constitution to bring a lawsuit? And in both of those cases in Florida and California, the courts basically leaned on that is an avenue for the legislature to decide who can bring a lawsuit and who is protected under the Constitution. And both found that BINA 48 is not protected under the Constitution and therefore could not bring suit.
But in
however, they
but in
say
that
they're-
case, BINA had not. It wasn't claimed in that case that BINA had done anything improper or anything wrong. That was a
Correct.
passive case.
Correct, Your
She
Honor.
was passive in that case, but in this case, it's claimed by Mr. Fairfax that this is different. This is an active
Yes, Your
case. This is active participation
Right.
by her. So
Right.
to that extent, do you see any difference, or do you think that that case is still controlling?
I believe that in this case, there is an alleged claim, and I would submit that it's still plaintiff's burden to prove that there was appropriation of the funds by BINA 48, something which he has not done and will not be able to prove, Your Honor. In the prior cases of 2003 and 2004, while it was an active case, correct, on BINA 48, the issues were still threatening to be unplugged, in essence to remove her of her life. So I would grant that in that case it was a very extreme issue that should have required the assistance of the court, because we are talking about a life and death situation. And the BINA 48 was not granted her day in court. Although I would like to clarify that while the courts argue that they were leaning against granting standing, both courts have stayed their order pending an appeal to a higher court.
Now,
The
Ms.
only-
Klein, let me ask you this. BINA 48, I guess, was very, very unhappy with having lost the decision in the first case, right?
Yes, Your Honor.
Okay, and in that case, there was a threat that her power supply was going to be turned off, right?
That's correct, Your Honor.
And here in this case, again, there's a threat, right, as I
Correct.
understand, that the power source is going to be turned off.
Correct.
Not only that, but he got married, Fairfax got married and wasn't paying attention to her anymore, right?
Well, those facts I would dispute the issue of BINA 48 being angered.
But why
or-
did she transfer the funds on February 14th? Isn't that Valentine's Day?
Well, I would still dispute that it's plaintiff's burden to prove that money was transferred to begin with, Your Honor. So I would still
But
dispute
assuming that,
funds were
assuming that,
transferred.
assuming that counsel is correct,
Yes, Your Honor.
okay, naturally Fairfax is looking for his day in court. So
Correct.
assuming that he's correct in that, do you see that there's some type of, because we knew there was some type of attention getting in that first case, is it possible that there may be some type of attention getting in this case
I
as
would
well?
argue the issue of a motive, a human motive, would be
Okay.
something that the plaintiff should, although for a breach of contract, I don't see a motive being an element of the claim. However, I would submit that that's for the plaintiff to bring up, that she was motivated.
But
as
let me
the
ask you this,
equivalent of human.
if in fact it's shown that she did take the money and put it into this account, is it possible that one of the defenses may be that, well, there was no intent to appropriate or steal this money, it's just an intent to kind of get back at him for what he was trying to do?
I
And
would not speculate as to the reasons if my client took the funding. I would
If
not
she took the
speculate as to
funding,
the reasons for that. I would think that would be a separate case where we would bring up those issues.
okay.
and
Let me
argue
ask
them.
you a couple of questions, Ms. Klein. Your client, when she, I think one of the things in your brief that you mentioned is that she's not capable of entering into a contract because she doesn't have capacity to enter into a contract because she's not a person. Is that one of the arguments that you were making, that you cannot enter into a contract if you're not really a
Yes, Your Honor.
person?
Well, the argument actually is plaintiff has brought a lawsuit for breach of contract. In order to win, he has to prove the elements of a breach of contract. One of those elements is that a valid contract existed between BINA 48 and Charlie Fairfax. So I'm not disputing whether, the argument is not whether BINA 48 is capable of being involved in a contract. It's that it is plaintiff's burden to prove in this case that there is a breach of contract.
But now, you know, and of course, sometimes the courts can liberally construe the pleadings, but now the issue has come up whether or not there's, in fact, a partnership. And also, even if the partnership theory falls, is it possible, even if there was no express contract, even if there was no written contract, is it possible that a claim could be made for a quasi-contract, saying that there was unjust enrichment here? Is there possible
Well, I think
is that a possibility?
Well, Your Honor, I think courts have leniency.
Mm-hmm.
However, there's also under Alabama law that there are definitions. The legislature creates the statute, enacts the laws. The court interprets them.
Mm-hmm.
In this case, both under a breach of contract claim and a partnership agreement,
Mm-hmm.
there is a definition that the agreement is between a person or entity. Under Alabama law and Alabama Code 111, meaning of certain words and terms, the word person, while it includes corporations and natural persons, however, these are entities, person or corporations, that are recognized by law as having the rights and duties of human beings. That's the Alabama Supreme Court in
So then
2002.
you're saying, again, getting back to this, since she's not a person, then she can't be subject to an agreement then, right? Also,
Correct. Under
yeah.
Alabama law.
Now, let me ask you this. I assume that, you know, your expert services come with a certain price as well. Were you retained by?
I was retained, but this is a pro bono
This is a pro bono. Okay.
representation.
Okay. So you didn't have any retainer agreement with BINA 48,
No
did you?
retainer, however, I will admit to the court that our lodging and food accommodation and transportation are being provided.
Are being provided. Okay. Now, assuming for the moment that for whatever reason BINA 48 retains this $10 million, okay, that she's taken and retains this $10 million, do you think she'll have to pay taxes on it?
Well, again, if she has this type of funds, if she is recognized by law as being a legal entity, and the reason I say that is because, unlike plaintiff's counsel, I do not agree that it, under the Constitution or our notion of what's just and fair, is that you should be required to have a legal duty.
Let's, assuming, again, this is
Sure.
just hypothetical, assuming that she now has the $10 million, right? Do you think that the good state of Alabama would be looking for some taxes on that?
I think
And
that-
maybe Uncle Sam as well?
I think the good state of Alabama is always looking for funding.
Okay. Now, will her defense, in the event that there was a suit brought by the tax department, would her defense be that, hey, I'm not a person, so therefore I shouldn't have to pay any taxes?
As her counsel, her defense would be whatever is available under the law and the Constitution.
Uh-huh.
And unfortunately, as prior courts have held, she has no legal standing, no,
So Charlie may have to pay the taxes, but BINA may not have to pay
may
the
not,
taxes.
correct. And that is a protection under the law in the sense that if she is not constitutionally able to bring a lawsuit for the court system to give her justice, it doesn't seem fair and equitable that she should be required to be hauled in court and provide a legal defense. I don't think the framers of our good Constitution or our current government would find that as equitable by any means, that as plaintiff's counsel has said, that you can be hauled into court to defend, but you have absolutely no rights
Now,
for
a
protection.
quick question I have here about BINA. This online game that she was involved in with Fairfax, I assume that the points that they accumulated were from other players throughout the country?
I understand that's correct. It's a
Right.
virtual
And
game.
maybe from some other players throughout the world as well.
I would assume so, Your Honor.
So she did some substantial activity online which affected players in other jurisdictions as well. Would you
I'm
agree
not
to that?
sure if that's how the
Mhm.
software works, as far as I
Well, did she
understood.
accumulate, were points accumulated here?
As I understand, points were accumulated, but
And
not.
did those points, were those points have a monetary value?
Yes, Your Honor.
Okay.
But I think where you are alluding the point
Mm-hmm.
is that BINA 48 herself was playing the game, whereas from the facts of this case, as plaintiff has shown
Mhm.
from his memorandum, is that actually the software used by BINA 48 interacted with his arm and
Mhm.
the brain gate system in order for Charlie Fairfax himself to play the game. So whoever was controlling the game person
Mhm.
and acquiring the points was really Charlie Fairfax.
So she
The
was assisting him.
BINA is the system that
Okay.
allowed him to control his arm in a virtual reality. She was not making the decisions on where this.
Now, assuming that he could prove that, in fact, she transferred these funds to an account that's not accessible to her, well, let's backtrack a little bit. Was there, how would you describe this relationship between BINA and Charlie?
Since the plaintiff has brought the suit, and according to his own facts, he purchased the BINA 48 system from Exhibit. He used the BINA 48 as technology in connection with his brain gate system. So according to plaintiff himself, BINA 48 was advanced technology, but not considered a partner, an employee. BINA was not paid any wages.
So she was not an employee, she was not a partner, she wasn't even an agent.
She wasn't even an agent.
An agent.
So
okay.
even under the Constitution, if plaintiff is arguing that BINA 48 is a partner, I would argue that then she would have all the rights entitled then to the partnership, which in this sense wouldn't be. It's almost like she's akin to a slave to the plaintiff, because basically
I think
he
those
purchased
arguments
her
were
and
made
controlled
in the
her.
prior case, and I think that you were successful in overcoming those arguments yourself.
Although this is a different fact
Okay.
scenario.
I think, okay,
Yeah.
anything further, Mr. Rustling?
No, Your Honor.
Okay, anything further?
Yes, Your Honor.
Okay.
I do have comments about the personal jurisdiction issue.
Okay.
And if the
Well, I'm not
court will
going to
indulge me-
entertain those comments.
Oh,
I'll tell
okay.
you why, because I believe that the court is satisfied that there was sufficient activity, okay? Assuming that we have a computer or an entity here that can be so-called sued and brought into court, I think that the court is sufficiently satisfied that the jurisdictional requirements have been met because of the activities, not only in Alabama, but the activities in many, many other different jurisdictions. You see, today when we transact transact business, or we engage in activities that are online activities, and those activities affect other jurisdictions as well, then we may find ourselves subject to jurisdiction, whether we like it or not, in those other jurisdictions.
Well, if the court will indulge me, I
I
believe
certainly will.
that minimum contacts is not the only requirement of personal jurisdiction.
Okay.
I believe that one of the requirements even by the courts, the U.S. court in Worldwide Volkswagen, says that the defendant must purposely avail herself of the privileges of conducting business. Likewise, there must be an element of reasonably anticipating litigation in Alabama. Those are all into the issue of foreseeability. If BINA 48 in other cases has not been granted her right to go to court or to be in court, I don't think she would have reasonably foreseen being hauled into court. So I believe there's a two-pronged test under the due process, both minimum contact and a foreseeability or availing yourself argument.
Okay, so you're saying that she can't be availing herself of the jurisdiction of the state because she's not capable as
Correct. There would have been
not
a
a person,
purposeful availing yourself.
and she
and
can't
a
be purposely
foreseeability.
involved.
Correct. And I believe that before you get to due process, under Alabama 4.2, the long-arm provision says the basis for service is upon a person or entity. Again, person or entity has been defined as an entity, again, being recognized by law and having legal rights equal to a human being. So even before you get to the constitutional issue of due process, Alabama procedural law is the first step you go to. You don't just jump into the Constitution. You first go to Alabama, since we're in Alabama court. And Alabama has stated that an appropriate basis for service of process to an out-of-state defendant would be to a person or entity. Again, the person or entity has not been defined to include a BINA 48.
Okay.
Thank you, Your Honor.
Thank you very much. The court has reached a decision in this case. I had set out the facts at length in my earlier presentation, since the unfolding of these facts details were essential to what's going to be my determination here. I want to give special thanks and recognition to Mr. Will Rossellini, counsel for the plaintiff, for his brilliant work in creating and putting together the detail necessary for this dispute. And we also recognize Ms. Susan Finesca-Klein, counsel for the defendant, for her extremely talented ability demonstrated by the zealousness of her work and her representation of an otherwise quite unique client. And this court also extends a very special appreciation to Ms. Lori Rhodes, certified paralegal, for her invaluable assistance with providing me with crucial background materials relevant to the issues decided. The facts in this case seem to unravel like a science fiction novel, taking us on a journey far into the future where so-called intelligent computers are perceived by humans as being either mankind's salvation or mankind's destruction. Will we be able to adequately control such computers, or will our very creations destroy us? Will these creations be a Mr. Hyde or a Mr. or a Hal, or will they be more like R2-D2 or Sonny, who helped save mankind in iRobot? As mankind speeds along the highway of technological advancement, will we be able to safely manage those sharp curves in the roadway, or will we end up fatally crashing into that very concrete wall which we constructed to ensure our own safety? These are questions which are better left to future debate and future scientific novels, and upon which this court has no jurisdiction to speculate or to promulgate. However, this court, as fictional as it may currently be, is faced with what may very well become a true-to-life controversy which a future court appears to most certainly be called upon to resolve. Although this is a case of first impression, we have many historical precedents and guidelines upon which we can draw. We must settle our current disputes based upon what has gone before and based upon the present issues which face us. In resolving those current issues, were we to project ourselves far into the distant future, would be a substantial injustice to future generations of mankind. However, were we to ignore the natural progression and development of society, would that likewise be a substantial injustice to our past generations? So with this, we have embarked upon this glorious adventure together, stopping from time to gaze in wonder upon the mysterious sights which we have encountered. The law. In BINA 48 versus Exhibit Corp., California 2003, a mock action involving a so-called intelligent computer as a party plaintiff, the California trial court refused to recognize that such a computer could sustain a lawsuit against its own manufacturer. In denying BNA a preliminary injunction and in dismissing the case, the court stated, "I deny the injunction because I do not think that standing was a fact created by the legislature, and I doubt very much that a court has the authority in the absence of legislature." That was the Honorable Joseph P. McMahon. That California Supreme Court denied the computer's appeal. In BINA 48 versus Exhibit, Middle District of Florida Federal Court, in a second mock action commenced by the same called intelligent computer, the two judges en banc, Federal District Court was split on the issue of recognizing BNA 48's right to bring a lawsuit. Justice Silverman stated, "Unless and until there is a change in the consciousness of flesh and blood, voting people sufficient to cause our laws to embrace the concept of machine with human consciousness, the proponents cannot expect reasonably vindication in the courtroom." And that was the Honorable David E. Silverman. Judge Anthony Dutton disagreed with his judicial colleague on that esteemed bench. Each counsel understandably narrowed their arguments to the issues of standing and breach of contract, since those are the specific subjects of the motion. However, this court is not so confined and has the inherent power and the obligation to go beyond the claims and the contentions of the parties in order to afford the parties complete and substantial justice. To simply dismiss this case will certainly deny Mr. Fairfax's possibility the only remedy he may have. To simply sustain the case may be contrary to the ultimate interests of BINA 48. Although the claim of Mr. Fairfax's counts is couched originally in contract, a liberal reading of the papers filed demonstrates possible claims for partnership, quasi-contract, theft, conversion, fraud, deceit, or even breach of fiduciary duties. Although the defense of BINA 48 is couched in jurisdictional terms, a careful review of the entire history and facts reveal an entity striking back at our system of justice from what may have been perceived by hers to have been a substantial injustice previously thrust upon her by that system. It may be said that hell hath no fury as a woman scorned. However, what this case demonstrates is that hell hath no fury as a conscious computer twice scorned. We really should not be surprised with having to confront a dispute such as the one at hand. What may be surprising is that we're facing it in this early age of our technological evolution. Can machines think? It was not so long ago that in order to replace that emotionally charged question, Professor Al Turing in his 1950 paper, Computing Machinery and Intelligence, proposed a test to determine a machine's capability to perform human-like conversation. In what became known as the Turing test, a human judge engages in a natural conversation with two other parties, one human and the other a machine. If the judge cannot reliably tell which is which, then the machine is said to pass the test. Professor Turing also predicted that in the not-too-distant future, machines would be capable of learning as well. Futuristic Ray Kurzweil predicted a Turing-capable computers by the year 2020. In 1985, a student lawyer, Robert Friedis, presented us with a very amusing paper entitled The Legal Rights of Robots. He predicted that by 2020, most homes will offer low-cost domestic robot options. He points to other futurists such as science fiction writer Isaac Asimov's classic 3 Laws of Robotics. Friedis also introduced us to Richard Lang, a former computer scientist at the University of Michigan who contemplated a day when human-level intelligent machines would with complex behaviors. In the matter of Wells versus the United States, the court inferred pilot error when switching from an automatic pilot to manual control in a crisis situation, thereby recognizing robot judgment as superior to human judgment. Dr. Josh Stars Hall, currently with the Institute for Molecular Manufacturing in California, wrote in the year 2000, the inescapable conclusion is that not only should we give consciousness to our machines where we can, but if we can indeed create machines that exceed us in the moral as well as the intellectual dimensions, we are bound to do so. In a 2003 article, Paul Almond suggests that with the idea of molecular nanotechnology proposed by K. Eric Drexler and with cryonics, we may not be far from achieving immortality, by which he refers to as indirect mind uploading, using software models of your mind previously stored. A presentation by Dr. Martine Rothblatt as counsel for BINA 48 and seeking to prevent its manufacturer from disconnecting its electrical supply, argued that BINA 48 was designed to think autonomously, to communicate normally with people, and to transcend the machine-human interface by attempting to empathize with customer concerns. In arguing that the court should allow BINA to sue, Dr. Rothblatt pointedly illustrated that standing has not always been limited to human beings, and that Supreme Court Justice Douglas suggested that in the context of environmental law, that legal standing might profitably be granted to even inanimate objects. In a presentation given in 2005, Peter Voss envisioned that what he refers to as artificial general intelligence, knowledge and skills may be acquired by computers by learning rather than by being programmed. Acknowledging that his next argument is controversial, he submits that once in that ready-to-learn mode, they will be self-aware. Voss predicts that the focus of the legal system at that time will be to protect humans or government rather than to protect the AGIs, but that the AGIs will be quite capable of looking after themselves. In 1992 Law Review article, Michael Rivard did an exhaustive study into these areas and argues that constitutional personhood should be extended to all species exhibiting self-awareness. Today, a Westlaw search shows that no less than 999 law review articles having referred to artificial intelligence, with no less than 46 such articles written just this year. In 2005, attorney David Calverley of Scottsdale, Arizona, argued, androids have begun to act in ways that on the surface seem human. However, no one is prepared to view them as anything other than property. As androids become more sophisticated and as engineers try harder to make them conscious, moral, ethical, and legal issues will arise. At that time, Professor Wendell Wallach, currently with the Yale Interdisciplinary Center for Bioethics, maintained that emotional intelligence may be required of a service robot and should take appropriate action if it senses that its behaviors caused fear or other forms of emotional disturbance in its clients. In August 2006, Dr. Rothblatt again visits the topic when she refers to early beginnings of a more direct immortality technology such as cloning and mind uploading into computers. And maintains that analysis be made of similarities between the bona fide authenticity of a robot's plea and that of a similar human. Black's Law Dictionary defines an entity as a real being, meaning something in existence. The definition goes on to define entity as an organization or a being that possesses separate existence for tax purposes. Certainly, if the Alabama Department of Revenue were to commence suit to collect taxes from BINA 48, her defense of lack of standing because she is merely property would be unfounded. The Alabama Revenue Code, Title 40, Section 40-1-1, defines a person as any individual, association, estate, trust, partnership, corporation, or any other entity of any kind. Webster's dictionary defines entity as a real substance, a thing that exists. By analogy, as an entity, if BINA 48 could be made a party to a revenue suit, she can be made to a party to other lawsuits as well. This court has considered all of the arguments of counsel and has considered our society's current state of technology, and from that I cannot conclude whether or not BINA 48 is in fact a conscious being or whether or not she is even competent to assist in her defense. I will therefore appoint 3 experts in the field of artificial intelligence to examine her to determine whether, in their opinion, BINA 48 is in fact a conscious entity, and if so, whether she is competent. They will make their report to the court and a hearing on that matter will be held. Counsel for both sides may employ their own experts to examine her. Experts' reports shall be exchanged prior to the hearing. If after the hearing this court determines either that she is not a conscious being or that she is not competent to render effective assistance to counsel, then the case will be dismissed and plaintiff will be relegated to whatever alternate remedies he deems advisable. If, however, this court determines that BINA 48 is in fact both a conscious entity and competent, this court will find that the court does have both personal and quasi-in rem jurisdiction, and she will be required to defend in this case and will be afforded an opportunity to interpose any counterclaims or to implead any third parties as a plaintiff. For purposes of this action, she will be deemed a quasi-person, not a real person, but sufficiently similar in relevant ways for jurisdictional purposes. Artificial persons have always been created and devised by human laws for the purposes of society and government. BINA 48's actions in assisting Fairfax in the Quest game in Alabama and in allegedly directing the transfer of the funds, allegedly, while part of the software system in Alabama subjects her to the Alabama jurisdiction. In fact, having made use of the internet to accumulate valuable points from players throughout the country and possibly the world, she'd be subject to jurisdiction in each and every venue where those other players resided. In its jurisprudential wisdom, this court will resolve the issues before it where possible so as to afford the parties full and complete justice and so as to avoid a multitude of lawsuits which would undoubtedly follow from a determination denying standing. It is so ordered.
You know, Al, the other night I was thinking about the mind.
Oh, yeah? What'd you come up with, D?
Well, come on over here and we'll sit a spell, and I'll tell you what I learned about the mind.
Must be held back like the runaway freight train flying down the track. Lickety-clap, the mind is a vast still ocean. Sail on to the shore beyond. Hear the crickets chanting at sundown. Oh, so hungry. See the white dove soaring through the bright blue sky, forsaking illusion. Mine, oh mine, like the diamond shining through the darkest hole. The wild stallion illuminates his soul. In the beginning was the Word. Through time it runs.